It's Thursday, the 26th of March 2020. Welcome to the Parklane Plowden bite-sized webinar. Today we're tackling questions about child arrangement disorders and child contact during the current COVID-19 pandemic. Just a quick disclaimer, this isn't intended to be legal advice personalised to you and your circumstances or the circumstances of your client. Each individual is obviously totally different, and of course the advice may change as the situation develops on the ground in respect of COVID-19 and the government releases further guidelines. Speaking today, we have Shabab and Hannah, who are both second six pupils in Chambers, Emily and myself, Kate, who are both tenants in the family team here at Parklane Plowden. We've tried our best to put together a guide to the most frequently asked questions in this brave new world. There is a lot of advice and opinion washing around on the World Wide Web, and we would really say please exercise caution in following this, particularly when advice without legal knowledge. Panic will help, and the best approach is that it's as consistent and routine as possible while still keeping children safe. Of course, it goes without saying that if you have any concerns, you should get in touch with your solicitor.
So dealing with whether a child arrangements order should be ignored in the current circumstances and a child should stay at home with their primary carer. It's important to remember that a child arrangements order is an order of the court that both parents have agreed to, and it should not be ignored. However, in the current circumstances, parents might find themselves unable to abide by the exact terms of an order. So for these circumstances, the most recent guidance dated the 24th of March from the President of the Family Division, Sir Andrew McFarlane, will be of assistance. The guidance provides that parents should undertake a sensible assessment of the circumstances. So this includes taking factors such as the child's current health needs, any potential risk of infection, the presence of any recognised vulnerable individuals in any household. So once taking all of those factors into account, a parent must act practically and reasonably. So where parents acting in agreement are able to agree that a variation of the order should temporarily take place, then they are free to do so through the exercise of their parental responsibility. It's important that any such agreement is written down, so this could be through email or text. Now, where parents are unable to agree the variations that should take place or the extent of any such variations, but one parent is sufficiently concerned that complying with the order would be against the current Public Health England or Public Health Wales guidance, then that parent may exercise their parental responsibility and vary the arrangements to the extent that they think is safe. It's important to remember that any decision that's made at this stage may be open to scrutiny at a later stage, and a court would look at whether a parent has acted reasonably and sensibly in light of the official advice that's been provided by the government and the stay-at-home rules. It's also important to remember that irrespective of whether an order is varied by agreement or otherwise, the courts do expect parents to reach alternative arrangements to establish and maintain regular contact between parent and child. So this will normally be through indirect contact, and it can be via FaceTime, it could be WhatsApp, Skype, Zoom, even by telephone. It's important that parents act practically in the circumstances, and the main point really to take away is that where coronavirus restrictions cause the letter of a court order to be varied, the spirit of the order should be borne in mind when making safe alternative arrangements for a child.
I'm going to answer questions about what you should do if your contact is usually supervised, how the current circumstances affect those arrangements, and whether contact can move to unsupervised as a way around this. For many families, particularly those who are in proceedings, it may have been agreed or ordered that your contact is going to be supervised either in a contact centre or by a third party. Unfortunately, contact centres up and down the country have had to shut their doors to stop the spread of the virus, and sadly it looks like they will be remaining shut until there's a relaxation of the current restrictions. We've posted a link to the NACC website, which will provide contact details for your local centres to keep you up to date with any news on their reopening. CAFCASS have indicated that they will be providing more information on the provision of contact centres soon, so that's something to look out for. If contact is supervised by a third party, be that a grandparent or a family friend, the government's latest guidance possibly throws up more questions than answers. The current staying at home guidance, that was the one published on the 23rd of March, puts a stop to all public gatherings of more than 2 people. So that would restrict a non-resident parent, a child, and a third-party supervisor from meeting in a public place. The guidance does say that children can be moved between their parents' home. The difficulty with that in this scenario is that it would seem to be contrary to the guidance for a supervisor to also come into the home if they don't already live there. No doubt lawyers will be looking for clarification on this in the coming days, and we'll keep you posted if any new guidance does come out. One question we've seen being asked is whether contact could move to unsupervised to get around this. The answer to that question will depend entirely on the individual circumstances of each case. And the reason for that is because there are a whole host of reasons why contact might be supervised. It could be down to risk to the child, issues of domestic abuse, and so on. Arrangements relating to supervision are likely to be a really tricky area for parents to navigate. But the most important thing is that parents act sensibly and safely when making arrangements, and that applies to all risks, not just those associated with COVID-19. If in doubt, then seek some legal advice. One situation where supervised contact is more common is where the local authority or CAFCASS are making inquiries to inform a Section 7 or a Section 37 report. If your case is open to a CAFCASS officer or a local authority worker who is still working, then they might be a source of support or guidance for parents. If contact is to be at the discretion of the author of a Section 7 or Section 37 report, then they should be consulted before any changes to existing arrangements are made. As Shabab has already set out, one of the best options for parents is to embrace technology. The president of the family division has been clear. The courts will expect alternative arrangements to be made to maintain contact. Skype, FaceTime, house party, telephone contact, these are all possible ways of doing that without having to meet face to face. And if you or your client has any particular difficulty in the relationship with the other parent, and there's perhaps a risk of conflict if you were to facilitate a video call, then perhaps look to your usual supervisors to see if they can help with video contact. There are a lot of platforms out there that allow for multiple participants to join into a call together. The best thing that parents can do at this time is communicate with each other and try to look for practical solutions that adhere to the public health rules.
So I'm going to deal with 2 questions. Firstly, what happens if we hand over in a public place? And then what happens if the child normally travels alone on public transport between parents? So taking the first question, if you normally hand over in a public place, this can continue to take place under the current guidelines. The current guidance is that if you're outside and meet someone from another household, you should remain 2 meters away from one another. It is therefore possible for public handovers to comply with this. So for example, if you hand over in a car park, where your child is old enough to walk, you can help them out of the car if they need help doing so, and send them off to your co-parent who is waiting at their vehicle, which should be parked 2 meters away. This is roughly the size of 1 car parking space, but 2 if you want to be safe. If, however, your child is not old enough to walk on their own, one option could be that the parent driving the vehicle remains in the front seat of the vehicle, while the co-parent comes to the vehicle to collect the child from their car seat. This will avoid contact between the 2 co-parents and meeting the guidelines. It remains important, however, that you still exercise the guidance to wash your hands after the handover and do not touch your face or eat any food until you have done so. If the public place that you used for handovers is now closed, so for example, you were handing over at somewhere like Escape, communicate with your co-parent and agree via email, text, WhatsApp, a new handover venue. This is to ensure that you are protected should there be any disputes down the line. The main thing here is communication. It is also advisable that you select somewhere nearby to the original handover location. So for example, a nearby supermarket car park. These are still open, they're a public place, and you're able to park in defined parking spaces so you can maintain your social distancing. Taking the second question, what happens if the child normally travels alone on public transport? There is no guidance currently on this matter, but a common sense and safe approach should be adopted. My first response would be that if either parent has a vehicle available to them, where possible, this should be utilised to minimise any risks and to ensure handovers can be conducted as safely as possible. My second response would be that those conducting essential work and who are unable to work from home are still able to use public transport, and therefore these services are still available. If both parents are content that travel can be conducted safely, contact should go ahead as it's been ordered. There are, however, a few more issues to consider here. Firstly, how busy is the service likely to be and whether social distancing can safely be complied with? So if you're living in London and the tubes are busy, we would probably advise against this. Also, the age of the child is relevant and whether or not they are likely to follow instructions, to not touch any surfaces, to make sure that they've washed their hands, to make sure that they're keeping their distance from other people, and to not eat on the public transport. Make sure you speak with the child before travelling so that they understand the importance of these instructions. And if you have available to you antibacterial wipes or hand sanitizer, provide these to the child during travel so that they can wipe their hands after touching any unavoidable surfaces, such as train doors or handle rails on buses. Services are also likely to be reduced and at different times at the moment, so check the timetables before the child travels. And again, make sure that any changes to timetables are communicated with your co-parent. And if the usual time is impacted, make sure a new time is agreed, and preferably in writing where you can. As there is a heightened risk involved in such transportation, if either co-parent is genuinely concerned about the child travelling in this way and whether it is safe to do so, the parties should communicate this with one another, explaining their concerns and acting reasonably, and to consider possible alternatives. Where possible, the parent with whom the child is currently staying with should offer video calling or a telephone call to the other co-parent for now. This again should be agreed between parents where possible. The ultimate aim is that the spirit of the order should be delivered, provided that safe alternative arrangements can be made.
So what happens if the child is doing schoolwork from home? Should the holiday arrangements kick in, or is it still classed as term time? This is a difficult question to answer and will largely be circumstantial. Parents should, where possible, have a sensible conversation to agree arrangements. The course has been very clear in its guidelines that it is the parents who have parental responsibility for the child and not the courts, and so the parents are best placed to make the most sensible arrangements for their particular child, taking into account their circumstances. Child arrangements orders have a caveat allowing for parents to agree alternative arrangements if that's appropriate, and this is a circumstance where that could be utilised. It may be, for example, that one parent is a key worker and needs to go out to work regularly, whereas the other has more flexibility to offer childcare or work from home. It's these sort of things that should be taken into consideration. In the event that the relationship is very acrimonious between parents and agreement can't be reached, the CAFCASS guidance is that as much normality and routine should be maintained as possible. This would suggest that any period of time which would normally fall within term time should continue to be classed as term time, regardless as to whether or not the child is in school, and any period which falls in school holidays that have already been scheduled, for example the upcoming 2-week Easter break, should class as holiday, and holiday arrangements should swing into place. Ultimately, though, there are no right answers, but parents should think very carefully about what's right for their child and try to avoid unnecessary conflict. The courts will, of course, when everything is hopefully back to normal, be scrutinising the decisions that are made, and parents should think carefully about what view a court would take if arrangements were changed or weren't able to be agreed. So what happens if the child becomes unwell or the parent becomes unwell and needs to self-isolate? Well, this is a much more straightforward question. clearly the child or the parent must self-isolate and remain where they are. If it is the child who falls unwell, the parent where the child is not staying, so the other parent, must be kept informed as to the child's condition. This will clearly be a very, very worrying time for any parent, and communication will be key. I would suggest that communication about the child's condition should be at the very least daily, and if the child becomes more significantly unwell, a phone call should be made to the other parent to keep them informed. If the child is well enough, alternatives should be considered, such as Skype or FaceTime and other social media. This will allow the child to continue to spend time with the other parent. CAFCASS have released some guidance for parents who this may be new to, about the sorts of things that can be done by Skype or by FaceTime. They've suggested, for example, a bedtime story could be read by the other parent over the telephone. Songs could be sung, or with older children, perhaps a film could be played and both parent and child comment to each other in real time. If the child has visited the other parent within his 14 days and then falls ill, then that parent should also take steps to self-isolate in line with government guidelines. This webinar has touched very lightly on what is an ever-shifting position, and it's likely that as things bed down, we will all work out what the new normal is and receive further guidelines. We intend to follow this webinar with further in-depth seminars and legal clinics, so please watch out for details coming soon. There may be a chance to put your questions to our team. Court hearings are continuing to go ahead by Skype, and solicitors and barristers are still at work. If you're a solicitor and you are concerned about the arrangements for your client, please feel free to contact us at Parklane Plowden for advice, and we will be happy to help where we can. If you're a parent and you need advice on what the best arrangements are for your child in line with your child arrangements order, please contact your solicitor or barrister for their assistance. A list of resources will be set out in the accompanying text to this webinar to assist parents and solicitors at this difficult time. Also, watch out for our public law webinar coming out today in respect of contact with children involved in care proceedings. We are having a bit of an experiment here at Parklane Plowden and decided to film the 2 videos on the 2 most popular online video platforms, so Teams and Zoom, to test out the different products. Let us know what your views are, but it seems at the moment that Zoom is the winner. Thank you for joining us today and stay safe.